Alred Jamar Jackson. Mr. Jackson has 2 cases pending, a 2021 and a 2024. Motion to revoke bond has been filed.
Judge, and he still intends to enter a plea. We're ready to go forward, except for I'm just still waiting to make sure I can tell him all the conditions.
Yes, right now, case ending in 00217, count 1, 12 months to serve, 10 days, balance probated. He needs to complete the substance abuse and alcohol evaluation and treatment, and the drug or alcohol risk reduction program, 40 hours of community service, a fine of $500, no drugs or alcohol, and 1 AA meeting per week. That's count 1. Count 2, a fine of $200 to be suspended. Count 3, a fine of $200. And then count 4, a fine of $100. And then for the other case ending in 05750, 12 months probation, a fine of $300, 40 hours of community service, and to complete the family violence intervention program. And then count 2 would be non-pros.
And that is to run concurrent with the other case, or?
That's fine, that's fine.
My client has indicated that he would like to take this plea under the First Offender Act. I believe he's eligible. Is there any objection?
Which part? Both of them?
No, that obviously I understand that the DUI charge is not eligible for first offender. I'm saying the family violence. The simple battery family violence.
If he's eligible and wants to use it, I don't have an objection.
Judge.
Yes.
Yes, Judge. That is we're prepared to go forward on the plea.
And there's 3 cases, right?
Yes, Judge. The other case is not on the calendar. We would like to address that case separately. That is I understand is one of the basis for the motion to revoke bond. However, he hasn't. I don't believe he's been arraigned on that. He does wish to present a case. I mean, a defense in that.
What's the 3rd charge?
It's a reckless conduct. It has absolutely nothing to do with either of these cases. And he intends to present a self-defense or defense of others defense in that case. And so we would just ask that he be allowed to handle that separately now that he has resolved these 2 older cases. The reckless conduct case is brand new.
Yeah, it's a felony.
The reckless conduct?
Yes, that's when I filed the motion to revoke on.
No, I'm saying I thought I saw it on my calendar the other day. So it's the reckless conduct this felony reckless conduct?
Yes, Your Honor. Let me just make sure based off of what I
thought it was a misdemeanor as well.
Sorry, it's misdemeanor. I'm sorry. Yeah.
Okay. Yeah, because I remember seeing it on my calendar because I was fussing at this young gentleman who seems to not be able to get it together. 1 second.
Okay. And Attorney Lynch, while the judge is off the bench, I am going through his criminal history. It appears that he may have had a felony. Can you just confirm? Because if he had a felony, he won't be able to use the first offender. I'm showing a failure to appear felony for kidnapping. So he might not be able to use first offender if he has a felony. Just to give you a heads up.
He's indicated he's never been convicted of any kidnapping offense.
Is that, it's on a history, so.
But as a conviction?
It says the failure to appear. I don't see the conviction because it happened in 2012. So I can't see it on here, but it does say failure to appear felony for kidnapping. Just to give you a heads up. So he may not be eligible.
Well, So I haven't, so I believe he is eligible because he has not been convicted of a felony and there's no felony pending. So.
Well, I don't know if it's been convicted or not. Like I say, it's an old case. I don't see it on my GCIC.
Okay. You're safe.
But we're ready to proceed, Your Honor.
Okay. I don't think I have to deal with the reckless conduct right now because it's not before me. If he wants to do it under first offender, that's fine. But if if he's ineligible for it, it's not going to go through.
We understand that, Judge.
Okay. All right. Mr. Jackson, raise your right hand for me.
Yes, ma'am.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
You can put your hand down. You're before the court on 2021 CR 06126, Allred Jamar Jackson. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is with you at the podium. You're charged in this case with simple battery family violence, count 1, simple battery, count 2, simple battery family violence, count 3, and simple battery, count 4. How does your client plead to the offenses before the court, Mr. Lynch?
Judge, it was a guilty plea under the First Offender Act to count 1. And I believe that was the only plea that the state required in that matter.
All right. So counts 2, 3, and 4 will merge.
Yes, Your Honor.
All right. And on the case 2024 CR 03196, DUI drugs, improper lane change, impeding traffic, drug objects, distracted driving, seatbelt violation, and marijuana 1 ounce or less. How does your client plead to the offenses before the court?
So it's a guilty plea to count 1, Judge. Nolo plea to count 2, and I believe a guilty plea to count 3. And the state wants a guilty plea on count 4. And what we're pleading to, I know the state's going to no pros count 7, but we'll plead to, which, did you indicate you were going to no pros another count other than 7? I know he's pleading to every other count.
Yeah, that's fine. Yep, that's fine.
What now?
So guilties, so count 7 is no pros, guilties to 5 and 6.
All right. On case 2024 CR 03196, by entering a plea of guilty to counts 1, 3, 4, 5, and 6, and a Nolo plea to count 2, count 7 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Jackson?
Yes, ma'am, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. And also for the record, unfortunately, I did read off the wrong recommendation, but again, it's still no jail time, Mr. Attorney Lynch. But again, 1 second, let me go to the.
Is this for case 1 or the second case?
For both. So for case number 2021 CR 06126, let me get the factual basis. And like I say, it's still no jail time because he completed whatever time already. Let's see. So on or about July 8th of 2023, Clayton County, Georgia. Officer Braumuller did see the defendant driving a silver Chevy 1500 on Highway 85. He saw the defendant swerving from the turning lane into the roadway and then slowed down. By impeding the flow of traffic on Highway 85, Officer Braumuller got behind the vehicle, conducted a stop. He did notice that the defendant was not driving a seatbelt. During his investigation, while speaking to the defendant, he could smell a smell of odor of alcoholic beverage coming from his person, as well as the odor of marijuana. The defendant had slurred speech. The defendant did agree to standardized field sobriety tests in which he failed all those exercises. The defendant, Officer Braumuller, did locate marijuana off the defendant as well. Your Honor, for count one, the state's offer is actually 12 months to serve, 4 days, credit time served, balance probated, a fine of $500. 40 hours.
This is on the simple battery case?
Oh. Sorry. Simple battery, the fine is 12 months to serve, 3 days, community time served, balance probated. And then a fine of $500 to complete 40 hours of community service, to attend the firearm safety class, to forfeit his weapon. And that's it for that count.
Are you sure you didn't read possibly a recommendation?
Okay.
Reckless conduct
These
case?
don't make sense. So here's the problem. With the battery, there should be some anger management or family violence intervention.
With that one, let me go back to the fast.
Yeah, just slow down, Ms. Hagler. We're not rushing. Just go
I have all
ahead
these files.
so you got 3 files for Mr. Jackson. It can be confusing. Let's go ahead and find the one for the battery and the
Okay.
one for the DUI.
All right, I think here we go. Okay. And again, thank you for your patience. On or about March 30th of 2024, Officer K. Pullin, Pullin, was dispatched to 5991 Riverdale Road, Atlanta, Georgia, 30274, Clayton County, in regards to a disturbance. When he arrived, he made contact with the defendant. He stated that he shot at another subject that was attempting to enter his vehicle while in the store.
You're reading a factual recommendation for the reckless conduct charge.
No, this is the simple battery.
Are you sure? Because that sounds a lot.
Jackson, right?
Yeah, the fact.
Wrong Jackson.
No, it's the right Jackson, but it's the wrong case. That's the that has to be the reckless conduct case. The simple battery case does not involve a firearm.
I don't have a reckless conduct on my calendar. Hold on.
It's not on the calendar.
The first name is Alrad, right?
Yes, it's the right defendant, but that simple battery case does not involve a firearm.
Listen, 1 second, but that's I don't see. Oh, 6126. One second. Okay, gotcha. Here we go. All right. Okay. So on or about May 20th, 2021, Officer J. Mustafa completed a proper cause affidavit for battery, family violence, and simple battery against the defendant. Officer Mustafa was called out to 8146 Huntington Drive, Jonesboro, Georgia, Clayton County. Pursuant to the probable cause affidavit, the defendant attacked his nephew, Malachi Jones, by pushing him to the ground, punching and causing visible injuries to his left hand, his pinky on his left hand. The defendant also punched his mother, Carolyn Jackson, on the right side of her head. And this incident did occur in the presence of the defendant's sister, Bernadette Jackson. The defendant did live with Carolyn and with Malachi at the time of the incident. So, Your Honor, for count one, it's 12 months probation. 12 months probation to complete the family violence intervention program, 40 hours of community service, no violent or harassing contact with the victims, Malachi Jones and Carolyn Jackson, and a fine of $300. Counts 2 to 3 will merge, and then count 4, 12 months probation, a fine of $100, and to have no violent harassing contact again with the victims, Malachi and Carolyn.
Okay. All right.
All right, for the second case, ending in 3196. Okay, I went earlier. I think I read those facts already, Your Honor. So again, the recommendation for that one, okay, is going to be count one, 12 months to serve, 4 days, community time served, balance probated, a fine of $500, 40 hours of community service to complete the drug risk reduction program, random drug screens, the substance abuse evaluation and treatment, and follow their recommendations, no drugs or alcohol, and to attend 1 AA meeting per week or NA meeting per week. Count 2, a fine of $100. Count 3, a fine of $100. Count 4, a fine of $300. And then the state will not prosecute counts 5 through 7.
All right. Anything else, Mr. Lynn?
Nothing at this.
All right. So on the case 2023, I'm sorry, 2021 CR 06126, sir, I'm going to accept your plea of guilty to count 1 and count 4 under first offender statute. On count 1, I'll sentence you to 12 months to probation to take a family violence intervention program class, 40 hours of community service. You're to have no violent or harassing contact with Caroline Jackson and Malachi Jones. You'll pay a fine in the amount of $300, $444 with the surcharges. Is that what that will total? On the count 4, 12 months to serve, 12 months to serve on probation, $100 fine, which will be $151.50 with the surcharges. That's the total for that. And no violent or harassing contact. That will run concurrent with count 1. And those are all under first offender. On the next case, 2024 CR 03196. On the first count 1, 12 months, 4 days, credit for time served. Balance will be probated for you to pay a fine in the amount of $500. It's going to be closer to $1,000 because of the enhanced fees from the state before DUI. You'll also have 40 hours, additional 40 hours of community service. You're to take a risk reduction course, have no alcohol or illicit drugs during the course of your probation, and you will be tested randomly for alcohol and drugs. You're to take a substance abuse evaluation and any treatment that may be ordered. You'll do 1 AA or an NA, so 1 Alcoholics Anonymous or Narcotics Anonymous class per week, and show proof of that to your probation officer. Count 2 will run concurrent with count 1. It's an additional fine of $100. That's $151.50 with the surcharges. Count 3 will run concurrent with count 1. It's another $100 fine, $151.50 for surcharges. Count 4 is a $300 fine. That's an additional $444 total. That will run concurrent with count 1. And counts 5 through 7 will be no pros per the motion of the state. Mr. Lynch, anything on behalf of Mr. Jackson?
Nothing at this time, Your Honor.
Mr. Jackson,
Yes, Your Honor.
it's a lot cheaper and a lot less of a taking away of your time and freedom to toe the line. Yeah. You got a lot going on here, sir.
Yes, Your Honor.
It's a lot of money, but it's also a lot of a time commitment. You got classes that need to be done. You have community service, at least 80 hours of community service as I'm counting. So please don't, if you get in the weeds and you're having issues, the last thing you need to do is skip probation reports. The first thing that will get you arrested is not reporting to probation. And I've said this over and over again. I'm giving you all the cheat codes for how to be successful on probation, and people still won't show up. I guarantee you, if you fail to show up for probation, that is where they will send me a warrant, quick, fast, and in a hurry. Are we clear?
Yeah.
If you have any issues completing any of the fines and fees or any of the terms and conditions of your probation, talk to your probation officer. They will help you work it through. But if you just don't show up, you are definitely going to jail.
Yes, Your Honor.
All right. So when you leave the courtroom, you're going to go right, take a right, go into courtroom 305. The first double doors, when you walk through the first set of double doors, there'll be an office and the probation expert will be in that office. Miss James, if she's busy with somebody, just wait till the hallway until she calls you. She will do your probation intake, ask any questions that you need to ask about probation, ask it about anything that involves your work, your travel, anything that's currently going on in your life that could be a hindrance, but understand that probation is the priority because I could always put you in jail.
Yes, ma'am.
All right. And that's not a threat. It's just that when I tell people I'm putting you on probation, you have the freedom to work and continue your life as long as you do these things. People still mess up on probation. I can put you in jail if probation is not for you. That's all I'm saying. All right. So go on outside and meet with Miss James, and after that you can leave. All right. Then